Okay, Mr. Coggin, did I say your name correctly? Is it Coggin?
Goggin, Your Honor.
Okay. Let's go ahead and get started. Would you like to reserve 5 minutes, sir?
Yes, Your Honor.
Okay, we're ready whenever you are.
Good morning, and may it please the court. My name is Kerry Goggin. I represent St. Andrews Verandas 3, the appellant in this matter. We are here today appealing an order denying our motion to compel appraisal for a first-party property insurance claim arising from Hurricane Irma. Specifically, the order at issue was found by the trial court, or the plaintiff in that matter, the appellant here, was found by the trial court to have failed to comply with its obligation to provide timely notice of a supplemental claim.
Mr. Goggin, it might be a good idea for us to start right off and address American Coastal Insurance versus Ironwood, that decision that came out on October 27th of 2021 by our court, because it appears to be right dead on center.
Yes, Your Honor. And Ironwood, having recently come out, has made a couple of findings. Number one, the first finding is somewhat specific to that case where the trial court did not necessarily find everything it needed to in that instance in order to support, upholding its order to appraisal. Second, and I think perhaps more pertinently to today's inquiry, and which ultimately gets to the crux of this matter, Ironwood held that a claim is not ripe for appraisal until a coverage determination has been made. This court has previously made a determination in the cases of Leeward, in the case of Bellagio, and has followed the Supreme Court cases of Johnson and Lycia in ultimately determining that coverage is required, and admission of coverage specifically is required for appraisal to proceed. Ironwood here has basically determined that coverage determination was not made on a supplemental claim. So this represents a bit of a departure from the prior cases. The prior cases, Johnson, Lycia, Leeward, Bellagio, state that coverage must be admitted for a loss, and coverage is admitted by making a payment, by making a determination that some amount is due from the insurer to the insured. So ultimately, whether or not
maybe a departure, but we're all in this together. We're all stuck with it now, right?
So I think it can be reconciled, and ultimately, I think this gets to the main point here, which is that while that ruling I think is correct that there must be a coverage determination made, it is in line with Leeward, Bellagio, and the Supreme Court cases of Johnson, Lycia. Its particular application to a supplemental claim is not the most, cohesive interpretation of the insurance policy. So this all arises out of the insurance policy, and particularly a provision, this de facto alternative dispute resolution provision, which permits the appraisal of the loss. Now, the appraisal is just as to the amount of the loss when either party demands, when there is a disagreement as to the amount of loss. There's a provision for a supplemental claim, and in this particular case, that can be found in the appendix at page 292, that provision. There's a separate provision where this definition of claim, supplemental claim, arises. It incorporates the statute. This is at page 284 of the appendix. Unfortunately, our policy does not have page numbers, so I couldn't quite tell you which page it is, but this provision at 284, which incorporates the statute addressing claim, supplemental claim, which has been established in Ironwood, which incorporates the definition from Goldberg, states that a claim, supplemental claim, or reopened claim for a loss or damage caused by hurricane or other windstorm essentially cannot be brought outside of a limitation of 3 years. Now, our position ultimately here, and this is ultimately an issue with Ironwood, is this use of the terms claim, supplemental claim, this division of one loss, one set of damage from one hurricane at one property into separate times, separate pieces. It is perfectly appropriate to address situations as have arisen in the past. So for instance, there were cases, State Farm versus Fernandez and Hernandez, which were both Hurricane Wilma cases, where the case was filed in the loss was reported in 2005. And ultimately 5 years later in 2010, you have this quote unquote supplemental claim being put forth, a request for additional damages, a request for more money, in effect. You have a significant period of time elapsing there. This provision, again, referenced at 284, where it says a claim, supplemental claim, or reopened claim must be brought within 3 years, effectively it's not a statute of limitations, but is a limitation on the time within which you can request essentially more money. That is fundamentally different from what should apply to this ADR provision, what I'll just term as an ADR provision, a limited provision of appraisal, where here, and again, I don't think the policy misspeaks when it says the loss, the amount of loss must be determined. And actually, this is a good point to bring up the fact that the term loss is actually the predominantly used term throughout the policy. I looked it up, I don't remember this precise number, but I believe it's something around 493 separate times that the word loss is used. It is the focus of this policy. It addresses causes of loss. It says in the event of loss, you must, even where we're talking about post-loss obligations for ripeness under Leeward and so on and so forth, it is post-loss obligations. Appraisal looks at this scope, I think, specifically because it is limited, because it does not determine liability. It does not determine the amount that the insurance company has to pay. It simply says, this is the entire pie that we are looking at. The defenses, and this is established by Johnson, this was understood when I think Leeward articulated its ripeness standard, and these defenses are preserved for later determination by the trial court. Essentially, if there is a late report, and that is a traditional defense, which is preserved for later determination, late reporting, failure of notice, and so on and so forth, these can ultimately be determined after the more efficient process of appraisal by the trial court. So essentially, you could have an appraisal determine a panel of 3 experts in the field, presumably.
Well, here going back to Ironwood. Here's the problem with Ironwood. Ironwood basically recognized almost identical facts that we have here, that a late file claim was a supplemental claim, and that appraisal was not appropriate because the pre-loss conditions had not been met, which is exactly what's happened here. So Ironwood is mandatory authority for us. The facts of this case are indistinguishable from Ironwood. Are we not just bound to follow Ironwood, irrespective of all of these other things you want to talk to us about?
Well, so I think one distinguishing fact in this particular case is that Ironwood says a claim is not ripe for appraisal until a coverage determination has been made. There, the post-loss obligations address that ability to make that coverage determination. Here, the facts agreed upon, I think, and is articulated in the appellee's brief as well, state that, and I mean, this is the fundamental problem. We have a claim or a loss, I would put forth, initially reported October 7th, 2017.
Yeah, but it was a roof loss. And yeah, the adjuster came out and looked at the roof and found minor damages, about 2,000 worth. No one said, oh, by the way, we got window and door issues. He only came to look at the roof. And then 2 years later, there was this 5 million plus claim made. All the doors and windows were damaged, to the point of 5 million plus. So they're entitled to be on notice of that and to investigate that, and they weren't able to do that because they didn't have all of the necessary information in order to do that, which made appraisal premature. I mean, it doesn't seem overly complex. I mean, if you ask someone to come out and look at a roof, they're not going to say, oh, by the way, let me look at the doors and windows too. They're only looking at the roof, right?
Well, I think that's a fundamental point of distinction, whereas Ironwood incorporates the finding in Goldberg, and Goldberg has a very specific form of loss. I believe they mentioned in the facts there. It is a property loss notice. It's a capitalized term, so presumably they have that. What has happened here, or at least as so far as the record, and I don't know facts differently, what has happened here and what happens in most cases is people do not necessarily report to an insurance company that their roof specifically is damaged. They say, my property, the covered property, has sustained damage due to a wind loss. The facts in this case show that ultimately the insurer determines that, and this is a question that ultimately must be resolved one way or another. Who determines when and how a supplemental claim or an initial claim arises? Who determines the scope of the initial claim in the first place, where it's not, unlike Goldberg, which again, Ironwood incorporates, where it's not necessarily outlined as a clear fact. And here, I don't believe there was a particular factual finding as to what the scope of an initial claim was in the first place. Where here we have that initial investigation being done in November of 2017, we have a determination of $2,000 in liability being done by the insurer in November of 2017. And admittedly, sometime later, after this loss manifests, I think, the effects of it manifest somewhat more significantly. We have basically a full investigation of this claim occurring after additional loss is reported. And again, it is an additional amount. As Your Honor noted, it's a $5 million amount versus a $2,000 amount. It's a substantial difference. But what occurs after that report of we disagree, and disagreement is a prerequisite to appraisal. It's contemplated within that appraisal provision of the policy. What occurs after that is we have the reports from the association's expert being provided August 28th, and this is all on the record. I think it's actually in the appellee's brief as well. We have a sworn proof of loss, a statement of loss being put over to the insurer. We have records being provided to the insurer, the association's documentation. We have an examination under oath, effectively a deposition being provided to the insurer. And then ultimately and divergently from Ironwood, where it says a coverage determination must be made, we have, after this substantial investigation, we have the insurer sending a coverage denial letter on March 2nd of 2020. So ultimately, the question here is, how do we take a look at a case like this, where we have a report early on, weeks after the loss, and then we have a determination by an insurer as to apparently a final determination of what constitutes an initial claim, not necessarily determined by the insured, the one reporting the loss, but the insurer, the one who theoretically has a good faith duty to inspect and adjust the entirety of the loss. Because in cases like this, where we have a commercial residential policy and we have somewhat deeper pockets than perhaps an individual resident might have, an individual resident, I would say, and I think the reason that duty of good faith is imposed on insurance companies is not in the ability, it does not have the ability or the wherewithal to negotiate and to establish its claim in a much greater sense than the insurance company would. So ultimately, you have this case here where, as this loss develops, and again, keeping an eye on that 3-year limitation that's put in the policy, and ultimately it was integrated into the statute as well. This being, yes, it's later, but in many cases, losses are not immediately, the nature of them, they're not immediately discernible. So it's a year later and they say, okay, look, we finally understood that this is a loss that's in a greater scope than was ultimately determined by the insurance company. We have brought people in to determine that. We have put that forth. And then the insurance company here, and in many of these cases, conducts a very substantial investigation. This is not intended to be unfair to the insurance company, but as this is akin to an ADR procedure, this is akin to an arbitration. It was subject to the arbitration code until I believe about 2001. The correct scope of inquiry, if we're reading this cohesively, is ultimately whether or not the insurer can meaningfully participate in this discussion of amount in the appraisal process. Have they had sufficient investigation? Has there been sufficient compliance with post-loss obligations to allow that insurer to meaningfully participate? That is ultimately, I think, the correct scope of inquiry. And the problem here is that this division into claim and supplemental claim is that it restarts this clock. So instead of saying yes and acknowledging we have done all of these things, we have had effectively a deposition, we've had a statement, we've had documentation, we've had more or less discovery. It basically says, well, now as of this Tuesday, I have decided this is a supplemental claim and we get to do it all again, and appraisal is not right. If we look at it within the scope of loss, we avoid this problem where we can see that there's essentially this arbitrary determination. I mean, in this case, the increased scope of loss, if we look at the definition of supplemental claim, it's any additional claim. Well, the claim here is made basically by complying with the post-loss obligation of providing a sworn proof of loss. When that sworn proof of loss is submitted and does not match but exceeds the insurance company's estimate, that's a supplemental claim. How does compliance with a post-loss obligation beget an entirely different claim and therefore an entirely new round of post-loss obligations? So, I mean, ultimately, I think the fundamental holding in Ironwood, the second portion of Ironwood, where it says that appraisal is not necessarily ripe until a coverage determination is made. That is correct. And it follows Johnson, it follows Lycia, and it follows Leeward and Bellagio, where an admission of coverage, that determination, kind of regardless of what a letter from an insurer might say, their actions, I would say here, I would put forth to the court, speak louder than words, where that determination that payment is owed, that's an admission of coverage under Johnson. even if later you send a letter that says, well, geez, we deny coverage, I don't think that's particularly relevant where they're prior conceded that payment is due. Ultimately, on the facts of Ironwood, it was not positioned, I guess, sufficiently to support the court's finding that appraisal was right. And ultimately, in these instances, and I think it bears
You're out of
reading.
time, sir.
Thank you.
Okay.
And we request the court reverse the trial court's order and remand for further proceedings.
Thank you. Mr. Jones?
Thank you, Your Honor. Good morning, and may it please the court. My name is Ryan Jones, and I represent United Property and Casualty Insurance Company. I'd like to start where appellant started his argument, which is with this court's decision in American Coastal versus Ironwood. And Judge Morris actually chose the exact same words I used to compare the two cases, which is virtually indistinguishable. Both cases involve a claim for damage from Hurricane Irma, where damage to the roofs was reported in 2017 and damage to the windows and doors was reported in 2019. Both cases also involve an insured who sought to invoke appraisal. Both cases also applied the exact same policy definition of the phrase supplemental claim. And in Ironwood, this court concluded that the window and door claim falls squarely within the definition of a supplemental claim. That really sets the stage for the appeal that we have in this case, because the next part of the Ironwood case stated that you cannot have appraisal until the matter is ripe, which means there's been compliance with all of the post-loss obligations. So when we look at this case, we follow the exact same analysis that the court did in Ironwood. And then once we've determined that the supplemental claim must comply with all of the post-loss obligations, we can analyze that issue too. In order to do that, we can look at a line of cases from a third DCA that addresses exactly that, compliance with post-loss obligations as a prerequisite to going to appraisal. And those cases include Romay and Mango Hill and Hernandez. What those cases tell us is that before a trial court can compel appraisal, there must be a preliminary determination that an arbitrable issue exists. And that's the key, because an arbitrable issue can only exist after there's some meaningful exchange of information so that each party can arrive at a conclusion. Now, what the courts interpret that to mean is that it requires compliance by the insured with all post-loss obligations. And I think that refutes one of appellant's main arguments, because appellant focused in the brief and in the oral argument on the fact that there was an EUO, the fact that documents were produced, the fact that there was a report turned over. But what that argument does is attempt to sidestep compliance with the prompt notice requirement. That is unquestionably one of the duties after loss. And as we know, case law requires compliance with all duties after loss. In fact, the Hernandez case we cited in our brief goes beyond that and explains why. And Hernandez actually says that it makes sense to require compliance with all of those provisions because appraisal is designed to resolve a dispute over the amount of the loss. And that purpose can really only be accomplished after each party has had a real opportunity to inspect the damage and prepare its estimate of the loss. And that's really important, the real opportunity to investigate. The focus then is on that opportunity, because as we know, that's the goal of the duties after loss, to allow the insurance company an opportunity to investigate the loss at issue. So with that in mind, we can look at Hurricane Irma, which we know was September 10th, 2017. And then we can look at the date this window and door claim was reported, which is June 20th of 2019. And the focus to determine United's ability to adjust the loss is what happened in between, what happened in that gap. I'd submit to the court that probably the most important thing that happened in that gap is on July 15th of 2018, United's policy ended. And St. Andrews did not renew its policy with United at that time. It chose a different insurance carrier afterwards. The reason that's so significant is that when you have a property claim, the threshold issue is that the damage must occur during the policy period. Once that policy period ends, that every day that we move away from the end of the policy period, it gets harder and harder to confirm whether damage has actually occurred during the policy period. In this case, that determination becomes even more difficult And the reason it's so especially difficult in this case is that the insured made two attestations actually, on an insurance application, one in September of 2018 and another in July of 2019. In those applications, the insured attested that there was no existing damage to the property. And they signed that under a provision that says they have conducted a reasonable inquiry to answer that question. So based on that information, it wouldn't appear that there was any existing damage. And then, of course, 2 months after that last attestation, they submitted a proof of loss claiming nearly $6 million in unrepaired damage. So then the task becomes, can we attribute any of the allegedly existing damage to an event that occurred back in 2017? When we look to the record, there's absolutely nothing to make that connection. For example, there's no documentation of damage to the windows and doors at the time of Hurricane Irma. There was no documentation that was created at the time of Hurricane Irma. There is no damage that was reported by the residents to the windows and doors. The engineer hired by United could not make a determination whether any potentially wind-related damage was caused by Hurricane Irma or any other wind event that had ever transpired at the property. And then most importantly, the statements from the insured on their applications for other insurance directly refute any potential that there is existing damage as of 2017 or as of the end of the policy period. These are classic examples of where courts have found that there is prejudice to an insurer's investigation based on a delay in providing notice that cannot be overcome. In the words of the Hernandez case, United was denied a meaningful opportunity to investigate the supplemental claim. The trial court recognized this and correctly made that determination. That was a failure to comply with the conditions, and it precludes appraisal. Now, that is also very, very significant because it distinguishes the case that we're here to talk about today from this court's other decisions in Leeward Bay and Villaggio and Cayman. In those cases, the court specifically stated that compliance with insurance policy conditions was not an issue. The issue was focused solely on a misrepresentation or an overinflating of the claim amount, which is amount of loss issue. It is not a coverage issue, which is what we're hearing, or what we're dealing with today. So because of that distinction, the Leeward Bay and Villaggio and Cayman cases are not controlling. The Ironwood case is controlling. And the analysis of Hernandez from the 3rd DCA is exactly what we have here, and the trial court made the right decision. So for that reason, Your Honor, we're asking the court to affirm the trial court's decision. And unless Your Honors have any further questions, that concludes my submissions, and we'll rest on our brief.
Thank you very much. Mr. Goggin, you have 5 minutes.
Thank you, Your Honor. To address the issue raised first by opposing counsel as to the compliance with all post-loss obligations, the issue, again, is one of post-loss obligations. Opposing counsel had mentioned that it required prompt notice of the loss. It is an interesting facet of these cases that we have a loss being reported mere weeks after the actual hurricane, the actual incident giving rise to the damage. And we have a claim that a loss was not reported until years later. It relies solely on this division into claim and supplemental claim. Again, the Ironwood case requires that a coverage determination has been made. Here, the facts of this case articulate that a coverage determination was ultimately made by the insurer in March of 2020, that there was substantial investigation. Again, the inquiry here for the limited scope of appraisal should be whether or not there is a meaningful opportunity. And to this extent, we agree with the reasoning in Hernandez and Fernandez. We do not want, and I don't think the process of appraisal will be served by having one party completely and utterly unprepared. We agree that basically there must be an investigation, but the question that we have is how, where we have 2 investigations in this claim, where we have an examination under oath of the insured, where we have documents and reports provided by the insured, where we have all of this investigation. How do we ignore that and say that this investigation never occurred and that prejudice resulted? Only by arbitrarily assigning a supplemental claim label to some portion of this matter can we ignore what's happened between the years of 2017 and early 2020 in this particular matter? So to the extent that Ironwood ultimately says that appraisal is not ripe until a coverage determination is not made, that's a restatement of Johnson. It's a restatement of Leeward, where there must be an admission of coverage, itself a determination, prior to appraisal. Ultimately here, the decision of Leeward and Velagio, they permit dual track. In point of fact, Leeward very specifically states, and arguably conflicts with Ironwood to some degree. It states at page 1243, our disposition is without prejudice to American Capital's right to contest coverage as a matter of law and continue litigating its coverage defense after appraisal. So clearly, not all coverage determinations will have been made. That was the fundamental holding of Leeward and distinguished it from the 4th District cases of Demetrescu, Michigan Condo, and the like. And then ultimately, Leeward certifies conflict with those cases, saying to the extent they hold, the trial court must always resolve coverage disputes before compelling an appraisal. There's conflict certified. Ultimately, this is all reconciled by viewing what occurs here as a loss where it was, again, it must be promptly reported. We completely agree. The loss was reported 3 weeks after, and it must be reported within that 3 years. The insurer had the ability to negotiate and to include whatever provision it wanted in terms of that timeline. And at page 284 of this appendix, they've included that these claims, supplemental claims, and basically all of these additions to what's being requested must occur within 3 years. So how is it not prompt? If they've determined it's 3 years and we have claimed, requested, reported those issues within those 3 years, those are fundamentally distinguishable from Fernandez and Hernandez, which did not have the benefit of the same provision and occurred 5 years later. They occurred well down the road. So ultimately, where we're talking about prejudice, the line must be drawn at 3 years. If we're talking about prompt notice of a loss, it occurred 3 weeks after the initial, after the hurricane, I think approximately 3 weeks. So for this reason, Ironwood is not bad law by any means. It is controlling. It builds upon Johnson, it builds upon Leeward, and it says that coverage must be determined. In that case, it is distinguishable because there was not a coverage determination made. That is what we believe this court ultimately picked up on. It was a timing issue of the case filing, I think, rather than here where that coverage determination is made in 2020, a second request for appraisal is made March 4th of 2020, and ultimately results in this action. So ultimately, for these reasons, we believe that this can all be read very consistently, where the scope of the loss is the appropriate scope of inquiry rather than the division of claims, supplemental and initial, and the ambiguities that result in what constitutes the initial claim, what constitutes the supplemental claim, and who determines when they arise. And for those reasons, we ask that this court reverse and remand for further proceedings where the trial court may dual track or otherwise. So yes, thank you, Your Honors.
Okay. Thank you both very much. You did a nice job today. We're going to take a break now for 15 minutes. We will resume at 11:30. Okay.